Well, hello everybody, I think. And welcome back to Buckle Up, It's the Law. Sometimes I don't know if I actually go live or when I don't go live with this new setup because there's a button that I can hit and then it won't start, and then I'll hit another button and it will start. Sometimes it's one button and it works. So let me double check that I'm live. Okay, looks like I'm live. Awesome. Fantastic. Should have just read the chat. Good morning, everybody, and welcome back to Buckle Up. It's the Law, folks. For those of you who joined us yesterday, and those of you who haven't joined us yesterday, I mean, my goodness, it is starting to become a little spicy. I tried to tweak the camera settings a little bit. I think the video is a little bit better. I'm still on a little bit of a delay because I have to use two different settings. When I record my pre-recorded content, I can use the Elgato 4K web link, which is or whatever cam link I think it's called. It is incredible, but it times out every 30 minutes because of the default camera settings that I'm going to still figure out on how to work and yada yada yada. But when I'm going live, so I don't have to get up every 29 minutes and 59 seconds to push that little button in the back, I have to switch to USB. But the USB is a little bit lower quality and uses different settings, and for some reason creates this lag. And it is freezing today, folks. I mean, winter is paying us one last visit. That's why I'm wearing a hoodie, as people are saying. It is freezing. It's like 40 degrees, and it's going to go all the way down to 28 by tomorrow morning. But by the looks of it, that is the last time we're going to see degrees in the 20s in this winter cycle. We're going to see some 30s next week, but then after like next weekend, March, I guess it's going to be like March 28th, 29th, 30th, April 1st. We're going to see like 50s and 60s. But anyway, let's talk about Auntie Bev, shall we? So Auntie Bev is going to hear the arguments of the motion that we discussed yesterday. For those of you who were not here yesterday, let me tell you, basically, we have the federal case. And Karen Reed's team is saying, look, Judge, we can't start this trial because what if the Court of Appeals rules in our favor? What then? You're going to start everything over again? Like, seriously? Because Bev doesn't know. Even though they have lost so far, there could be at some point in the appeal, the Court of Appeals that they're in right now, which maybe chat can tell me what it is, because I don't know all the nomenclature of the exact courtroom that they're in right now, because there's way too much information to follow, and I can't follow it all. We have this appeal that is going to have a profound impact on Bev's courtroom. Because let's say the Court of Appeals agrees and says, you know what? Charges 1 and 3 shall be dismissed because we have courtroom affidavits from jurors saying, we voted not guilty. We voted not guilty. That's it. That's the end of it. That's the end of the line. There is no more, okay, well, mulligan, that's it. The prosecution will only be able to move forward on charge number 2. However, if they lose their appeal, well, then the jury trial will continue unabated. But we won't know until we have a ruling. And starting a jury trial in the midst of all this is ludicrous. Because, as I mentioned yesterday, Auntie Bev could theoretically be wasting not hours, not days, but weeks of the court's time. Think about it. Can you imagine? She's like, nope, the trial's going to start, and the trial starts, And then April 1st, we pick a jury, yada, yada, yada. The trial begins. Testimony, opening statements, testimony, direct cross, direct cross, direct cross, direct cross. And here we are. It is now the month of May. It is May 27th. We're approaching the end of it. And all of a sudden, the Court of Appeals goes, yeah, we're ruling in your favor. Charges 1 and 3 dismissed. Auntie Bev would have to start the trial over. You can't just like pick it up and scratch off the jurors' minds like, okay, options 1 and 3 removed, because the strategy by the defense has been a certain way. The jurors have already been led to believe a certain thing. Both sides at this point have in opening statements, weeks ago, I'm talking about in the future, will have already said, hey, we are pursuing 3 charges against her, and she's charged with 3 different charges. It just doesn't work, folks. Any way you try to slice it, it doesn't work. So today, they're gonna try and get Bev to grant. They're gonna try and get Bev to grant their motion. The defense is gonna ask a very reasonable request. Not only that, they have indicated in their motion yesterday, for those of you who were here, remember they said we are on an expedited briefing schedule. Normally, in a normal appeal, each party will have somewhere between 3 and 6 weeks, depending on which, if is it the brief, the response, or the reply, or if there's an opportunity for a surreply, which is extremely rare and usually not granted. So the initial brief, you're usually given like 6 weeks. They asked for 6 days. I don't know how you get a brief cranked out that quickly. I mean, they have a very solid team. They have probably Betero in the background working. They have Little and Alessi and Yannetti and Jackson. They're all cranking this stuff out. I don't know how you do a brief in 6 days, folks. That is a monstrous task. But whatever. They're doing it, and they're showing to the court that they respect the court's time. They're not asking for a continuance until July, August, September. They're asking for a 3-week continuance. That is extremely reasonable. Now, this is something you guys brought to me, and I was like, wait a minute. I did not know this. I read on my Twitter yesterday after I did my live, so unfortunately I didn't get a chance to talk about it yesterday, so I'll talk about it now. There was a moment, somebody said that Auntie Bev was like, well, the jurors have already been, like, the jury notices have been sent out, so delaying the trial will, like, confuse the process or something. I don't know. I don't know the exact language. But, like, basically the premise is the jury notifications have already been sent out, summoning them for jury duty. Okay, what's the problem? I have to reschedule jury trials all the time. Jurors get notified. Jurors get a call back saying, hey, come back laters. Granted, this is a highly publicized trial, so is part of the jury notice literally says, like, have you heard anything about the news? Check yes or no. And they found all the no's and brought them together? I don't know. I do not know. It's confusing and it's bizarre. And of course, people, because of the corruption, because of Bev's... by the way, I also learned she has presided over numerous other murder trials. And this is all hearsay. I don't have firsthand experience with this, but this is what I've learned through hearsay, is that some other trials she presided over, she was very fair to both sides, the prosecution and the defense. So there's something about this trial that's very personal to Bev. Very personal. And hopefully we'll get to the bottom of it one day. I have an Auntie Bev video coming out in the next few days, so be on the lookout for that. I also have my special surprise to finish up yesterday's awesome surprise. I told you something was coming. I told you on Sunday that Wednesday, Thursday at the latest, the hammer is gonna come down. Don't ask me how I know. I will never tell. I protect my sources. But I'm not done. The DUI guy said the DUI guy is still cooking. The DUI guy is still cooking. I still have one more uh, thing for you guys. It is going to be recorded tomorrow. Recorded tomorrow. I can't do it today. It will be recorded tomorrow. And it will be released, hopefully. It all depends on my editor because he's in Macedonia time. Shout out to you, Boyan. Love you, bro. Uh, he is on Macedonia time, so it all depends on like is the quicker we get done, if he's got the time, because he and his girl are in Paris right now. So it's actually he's on Paris time, I should say. But you know, it's pretty much the same. It's like plus minus 1 hour, 2 hours, no more than between Macedonia and Paris. I think it's one, but I could be wrong. But anyway, yeah, there's a lot of stuff coming, not just from me, but from the court as well. And I'm really looking forward to today. I had to jump on this one. I'm pretty much caught up to work. I have to do a couple more things. I have a couple of clients waiting, but they're probably still sleeping. Now it's 9 o'clock in the morning. Nobody's up at 9 a.m. I need to fix my watch. I just realized it always lags. It's perpetual date just. So I have to adjust it real quick. Sorry, you guys. Um, so yeah, I can't miss this for the world. I want to hear, and I want to react live to what Auntie Bev, because I mean, come on. Right now, I'm going to put a poll up and I'm going to ask you guys, how many of you think that she is going to deny the motion to continue? That's going to be the poll. Let me put the poll up. Here we go. That she is going to. Oops. That's me listening to myself talk about this. Here we go. Engage with your audience. Start a poll. So let's do this. Is Bev going to deny the motion, the defense's motion to continue today? Yes or no? We're just going to keep it simple. All right, poll is up. Poll is up. Go vote for it wherever it is on your screen. It'll probably be on this side. Do you think she's going to deny the defense's motion to continue today? I'm not going to answer yet. I want to let you guys vote first, and then I'll give you my opinion, because I don't want you to be tainted by like, oh, DUI guy said this, so I'm going to vote, in that direction. So I want you all to tell me, because look, the request is not unreasonable when you really think about it. When you really get down to it, when you really get down to the nuts and bolts of it, the request is not unreasonable, Your Honor. It's a 3.5 week delay, not even a full month. We've already continued it from January. Do you really want to be the April Fool's joke of the entire nation? No, I'm just kidding. They're not going to say that. Although that would be hilarious. It would be denied immediately just because you're snark to the court. Because judges are egotistical maniacs. But anyway, there is no reason to not grant this delay, this continuance. It's not going to cause a significant delay in the trial whatsoever. All it's going to do is going to give the opportunity for the parties to finish briefing, and once they're done briefing, start the trial. Once the court rules, start the trial. What's the problem? It's not their fault that they had to wait like 6 months for the court above that to rule. And it's really disappointing, but she denies pretty much almost anything the defense asks. She finally granted, or or not granted, she finally denied the prosecution's motion for sanctions against the defense. That was something. I know, but letting Bettero in, I mean, there's already like 4 seats at council table. To add a 5th one, it's too much. It's too much. And I get it. As much as I love Bettero and I think he's an asset to the team, I think adding him as counsel pro ac vice should have been granted, but she used the whole Turtle Boy thing as retaliation, and we all know what's up. We all know what's up. So, do you think Bev is going to deny? Is Bev going to deny the defense's motion to continue today? 150 of you voted. Literally, right down almost exactly. 3 out of 4 of you are saying yes, she is. 1 out of 4 of you are saying no, she's not. So it's not so lopsided. It's not so lopsided as I would have imagined. It's not like 98-2 or, 95-5. It's 74-26. My opinion is yes, she's going to deny the motion. Why? Because she's Bev. That's it. She's going to deny the motion, and that's just what's going to happen. Special case says, Larry, chat. That really doesn't help me a whole lot. I don't know what you're talking about. Oh, that's a hello. I thought you meant like look at the chat. I'm like, did I miss something? I don't know. Chat is my favorite. Chat is my BFF. So I'm always like on the lookout, like, oh, did I miss something? Something happened? Do I need to be informed? Did I misspeak? Chat always corrects me if I make a mistake, and they always fill me in if I don't remember something. So I love chat. Chat is the best. I am not ignoring you. I am filling everybody in. So anyway, I am very, very excited for today's proceedings, regardless of how they're going to go. I think that this is going to be let's see. I'm trying to refresh. There's nothing on NBC 10. Yes, my sync is off. I'm aware. I need to have like a running thing. Like, yes, I'm aware my sync is off. I don't know how to fix it. I tried this morning again, and it's like I said at the beginning of the stream, I have 2 different cords. One is HDMI and the other is USB. My HDMI times out. I don't want to be getting up every 30 minutes, so I'd rather just have this. It's better than nothing, because this I can stream for 8 hours and it'll continuously go. But the minute I switch to HDMI, every 30 minutes it times out and you will lose video feed, and I'll have to get up and tell it to start recording again. And I know what you're gonna say, like, Larry, there's a timeout button. Just set it to disable. It is set to disable. This is an internal camera mechanism that I have no control over. I have to like jailbreak the camera in order to get to that. So this year, depending on how it goes, thank you for the 1 gifted sub, Smoking Auditor. And Aaron Shirley says, is there a scenario where Auntie Bev is removed from the trial once the defense is out of options? Unlikely. Very, very unlikely, unfortunately. There is a scenario, but is it realistic? Almost certainly not, unfortunately. The hearing started. Not quite yet. This is what I'm seeing. Thank you, Smoking Auditor, for the 1 gifted. Is that another one? Wait, is that 2? Oh, thank you. Thank you. This is Boston 10 Live. I don't know. People are saying Melanie Little has it. Okay, let's go on Law and Crime then.
How can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Carney, so I'm asking that Mr. Carney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they...
Oh, I see. It's a different feed.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of the... We didn't see which case number was called for this Rule 17, if it was Mr. Carney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Cannoni, was if this issue was going to be on our case number. I specifically asked that question at Sidebar the day before yesterday, and she said yes. The Rule 17 that Mr. Brendan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the issue
This meeting is being recorded.
Are they trying to
Counsel,
ambush?
It has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Carney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here, and she has a right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but we...
Which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or a disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number, and the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Carney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. Correct. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
Did you give the court notice of that?
We did to Justice Cannoni.
Okay.
Day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration of the court such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Gradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally if counsel wants to join in my file. That's an issue.
I love Aiden's face. He's just like, yep. Yeah, that just happened.
Thank you, Attorney
Well, Your
Brennan.
Honor, I do object.
Well, of course you're going to
Ms. Reed's
object.
counsel
Fuck
and
you,
Ms. Reed do
Brennan.
not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at
Yeah,
council table.
sit the fuck down,
and
bro.
to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I like this judge.
I understand the court's concern, and I've looked at Addendum A as well, and have identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence
Thanks, Ms. V.
of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled, because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
ADA Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth's revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer. ADA Brennan, thank you.
And so in light of the fact that this information was seized pursuant
I
to
love
a
this
warrant
judge!
of cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, inevitably, the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannoni in a motion in limine regarding conscience of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Carney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
This is Aiden's case. What the hell just happened? I think it got overloaded, you guys.
Counsel.
Thank you very much, Your Honor.
This is Aiden's case.
Good
This is
morning,
not the Karen
Your
Reed
Honor,
case.
counsel.
Morning.
Judge,
That's why we have a
this
different
is
judge.
Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth
Yes.
is throwing,
Yes.
last-minute bombs
Yes.
out.
Yes.
I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed.
Yeah.
The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith
Yeah.
and not as a general fishing expedition.
Yes.
This is the ultimate fishing expedition,
Yes.
Your Honor. And I want to go back. When this
Yes.
happened, Judge,
Oh my
we didn't
God,
have a
yes.
fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me, counsel.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system.
Yeah, that's
They
true.
couldn't establish probable cause based on this information. And I remembered when this happened, just sort of, not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution as an attorney, I saw this, I read the search warrant, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it, and I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications.
Yeah.
And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants.
Yeah.
and talk to anyone she wants and communicate with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights.
I think the
present
judge
all
is going to
proofs.
deny
So when
Brendan's
the government
motion.
cites that just as a bare proposition, she tried to keep this secret. She communicated
could be
with
wrong.
Aiden Carney. Then we're going to make this
But I think so.
gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value. Your
Yep.
Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and failed. So that's
Yeah.
why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong, the government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney in consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, you know, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California, we talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right. Went to say that, oh, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation and the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime.
Yeah.
And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant?
Right. What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary, it's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor, that just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife communication.
Counsel, you're not asking?
No, not you. Just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications. We're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Exactly.
Thank you, counsel.
Exactly.
So, A.D.A. Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Lillard, Your Honor.
Thank you, Your Honor. Elizabeth Little appearing on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look... Attorney Bradle. Apologies, Your Honor.
It's a lot of
There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4.
Yes! Attack it! Attack! Attack it!
A single fact in the affidavit to show that it cannot
Yes!
prepare for trial.
Yes, the
without
rule of law is
production
back!
evidence. So just on that basis alone, the Rule 17 is deficient.
Deficiencies!
That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Yes!
Thank
Yes!
you,
That's a
Counsel.
swift kick in the
Please,
nuts,
Madam Chair, can you
mofo!
Response briefly.
You screwed up. Now you don't get to play.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the District Attorney's Office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradel. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information, to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know.
Really?
The defendant,
really?
Ms. Reed knows it as
So
well, because
intimidated.
If you do see the video,
Oh, goodness
with a
me.
smile, she acknowledges the consequence.
The Canton Mafia is scared of Aiden.
Seems to encourage it.
Okay.
Impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate.
What's
and
up, Flux?
She should decide the admissibility in the Commonwealth v. Karen retrial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
Oh my god. What the hell? No. What is this? What is happening? Get out of here. Let's go back to NBC because it's gonna resume at NBC 10, and I'll talk about it in just a second, folks. Don't worry. I am not going to leave you hanging. I promise. Okay, we got the OnlyFan. Oh God, what was that noise? Oh my God, you guys. Oh my God, what a morning. I am so glad I did this. I am so glad I did this. Oh my God. Like Like, this is hot fire. I can't believe I was debating. Oh my God, what is that noise? Ow! My ears are bleeding. Okay. It's from the camera in the courtroom. Anyway, I can't believe I almost passed this up. This morning I was like, I have work to do, but this might be interesting. And I was like, I'll just do some work. And then something pulled me by the teeth and said, Larry, you need to go stream this. And I was like, all right. You know, they're going to address the motion that I got my hands on for the first time ever first. And that's crazy. That's because I am working with the court, and the court is awesome. So, a shout out to all the clerks in Norfolk County, by the way. I want to say this. What just happened is entirely Brennan's doing. I don't think the judge had anything to do with it. I have a very strong feeling that Brennan tried to ambush. Let me move this so I'm not doing a free advertisement. the hashtag not sponsored. I believe Brennan is entirely responsible for this being a hearing by ambush this morning. This is Aiden Carney's case, and all of a sudden he's butting himself in, and Karen Reed needs to be in the courtroom. This is all related. I'm like appalled, but not surprised in the least. Brennan is a snake. And then Bradel made an excellent argument as to why you can't go on a fishing expedition a week before trial to see, maybe we can find some evidence. You have to point to a nexus of a crime being committed. Look, we have evidence. He literally said, we have some person in California who said this. Well, bring them in. Get an affidavit. Instead, they're just like, we talked to somebody. That's good enough for government work. You know, you've heard that phrase before. Well, anyway, I am very, very impressed with Liza Little's argument. I mean, she was up there for 60 seconds. She's like, Your Honor, this is facially deficient. Here's why. And what does it mean to be facially deficient? It means when you make a filing, by the way, it has to be made in a proper manner with the proper information and the proper documents and yada, yada, yada. If you screw that up, your filing may be rejected on that basis alone. And Liza Little pointed out something very procedural. It has nothing to do with the facts. Notice she did not argue anything about the facts. She just said, he didn't include this, therefore it's deficient, therefore it should be denied. And sat down. I almost done me creameth in my pants, you guys. That was beautiful. That is some of the sexiest lawyer work. And I'm not saying that because she's a female. If Jackson had done that or Yannetti had done that, I would have said the same thing. So I'm trying not to be sexist here. You understand the difference. It makes a lawyer salivate. You know, it's like, well, you remember this statute, 189A.010, subsection 1A, part 2? Yeah, you did not comply with part 2. You complied with part 1, but you failed to comply with part 2. Any judge in the universe would look at that and go, yeah, you failed to comply. Motion denied. You know, if you want to refile, you're more than welcome to. So it's so good. It is so good. I'm waiting on the video feed. As you can see, we are waiting on them to file back into the courtroom so we can do the Karen Reed hearing this morning. Flux, only you can decide that. Only you can decide that. FYI, just in case A. Reed says, just in case you all know, on HBO Max, there is a series on now of Karen Reed. Okay, awesome. Maybe we are going to get a chance to. I doubt I can like live stream it or anything. But oh my God, I can't believe I almost missed all of this. And look, did you see Aiden's face? Aiden's just sitting there. He's looking at the judge, and then the camera's over there, and he's like. He's just like smiling at the camera because he knows everybody's watching, and he's got cannon fodder for his show tonight, and this is his case. This is them prosecuting him for being a journalist, and a very unorthodox journalist, but a journalist nonetheless. Oh, God. Oh, this just made my week, you guys. Oh, I was supposed to be in jury trial this morning, but the prosecutor gave up yesterday. So it was a really bad case for the prosecution. Not trying to crap on anyone, but I was supposed to be in jury trial right now. Like, we would have been picking our jury as we speak, or maybe already doing opening statements. But the reason we didn't get that far is because it was a really bad case. Really, really bad case for the prosecution. And they caved at the 11th hour the night before trial. And it was the smart move. It was a smart move. We settled it yesterday, and our client is taking an amended plea this morning with just like $100 fine, and that's it. And he's ecstatic. He is so happy. I'm very happy for him too. Yeah, I mean, oh my God, this is so good. Oh my God. And we're not even at the good stuff yet. I mean, that was good stuff too, obviously. But we're not even at the good stuff yet. Because what we're missing right now is... Oh, somebody pointed out Brennan is not as confident in front of this judge as he is in front of Auntie Bev. That's an interesting observation. I did notice that too. I just didn't like articulate it yet. Whew, I can't believe I almost missed this. Oh man. Okay, let's see. So we're still waiting. We're still waiting on NBC 10. This was an appetizer. Now we get the meal. Now we're back to Auntie Bev's courtroom, and this is the Karen Reed case. And we are going to resume with the motions to continue, and we'll see what Auntie Bev says. Is she going to give them more time, or is she going to be like, no, great hair, don't care. I am just going to continue. April 1st, jury trial starts. Everything be damned. Oh, and I started saying this earlier. But I never finished the thought because we got distracted. So there's a lot of speculation out there right now that, like, why is Auntie Bev so married to this particular jury that is being selected? Because remember, I said, in my own cases, I can speak from experience. I come to court, the jury is there, but something happens, and we need to continue the trial. It happens sometimes. Or the night before, hey, don't make the jurors come in tomorrow, even though they're all on notice to appear. It happens. Things happen, okay? Sometimes a prosecutor gets sick. I'm not going to make a sick prosecutor come in to try a case just because I want to win. That's dirty. I don't play dirty. I like to play clean. I like to win cases on the merits. So if you're not going to give me an offer that my client is willing to take, we're going to go to trial, And so the most important thing about this case is Auntie Bev, there's word on the street, and this is all hearsay, there's word on the street that Auntie Bev is really attached to this jury. And I don't understand why. If that's the case, and we'll see what she says today. If she makes any mention at all of like, well, I would grant you a continuance, but the jury has already been subpoenaed to appear, not subpoenaed, but called upon to appear, and I just don't want to mess with that. It's a little too convoluted. It'll make my clerks work harder and blah blah blah. I don't buy it for a second. If that's going to be her fallback, if that's what people are saying, if that's going to be her fallback, if we see that today, my spidey sense is going to be tingling. My antenna are going to perk up, and I'm going to go, no. There is something much more sinister going on. But if she falls back on something else, that may still be a theory. But we'll see. I want to see exactly what is going to happen in court today, because today is the big day. Today is the decision, one of the last pretrial conferences before the jury trial is supposed to start, not this coming Tuesday, but next Tuesday. And today she has to decide whether or not that's actually going to happen. That's it. When are Megan and I doing our stream? We are working on it. Actually, that's a good point. We texted very recently. What did we agree upon? I don't remember. I have too many things going on. I have too many things going on. Where is she? She's in Scottsdale for spring break. Or did she come back already? Did Megan Fox come back from Scottsdale, chat? Chat is asking when we are going to schedule our stream together. I think she's back, isn't she? I thought I saw her stream the other day. Oh, sorry, you guys. I'm still writing the high of this morning. I mean, that was so good. That was so beautiful. Yeah, she got sick. Oh, no. Chad is telling me you got sick. I hope you feel better. I wish I could show you my phone. Actually, I guess I could. I guess I kind of could, because there's no sensitive information on here. Look at this. I said chat, and my phone wrote Chad. You probably can't see that, but my phone wrote Chad. Getting sick on vacation sucks, exclamation point. She said she'll be back Monday. Okay. We'll plan something next week. And hopefully I'll get my camera thing all fixed up by then, because this is no way to live, you guys. I have such an amazing camera. And I have to like... We are Chad. You know, the OGs know where this is from. You guys remember where Chad is from, right? CHAD. Because I was live in the line to get into the Murdaugh trial in South Carolina a couple of years back. Around this time? Yeah, somewhere around this time. It was like 2023, January, February 2023. And I'm standing in line, and there are these two lovely ladies. And I'm like, say hi to Chad. And they're like, hi, Chad. Who is Chad? And it spawned this creature that there was no Chad, because they don't know. They don't get it. It's fine. And they called it Chad because they thought it was like a man. It was like person, a friend, a buddy. Hey, Chad. They didn't realize Chad was like 5,000 people. So, hey, you know, what are you going to do? Oh. Say hi to Chad. They thought it was one person. Okay, so now we are getting ready, and this is what I thought we were gearing up for. I thought we were getting ready to hear arguments in the Karen Reed case about continuance. We did a poll. 78% of you are saying Auntie Bev is going to deny the defense's motion to continue, and 22% of you are saying she is going to grant it, and there will be a continuance. Chad is the collective. That is correct. I don't know what the delay is. Once again, this is all I am seeing. If you guys see something different, please let me know. I appreciate you guys alert. Oh, here we go.
117,
Wow.
Commonwealth versus
Speak of the
Karen
devil.
Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning,
Robert.
Mr. Alessi.
Good morning, Your Honor.
Robert
David
Alessi.
Giannetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with, it's paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument
Oh,
on
see,
why I
there it
should do
is.
this.
There it is.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril.
Yeah.
The case that we're defending right now, very clearly, is a murder case, ultimately, along with...
All three indictments, correct? You're defending all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter,
Yeah.
and there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree.
Yeah.
That probably is the better practice.
Wow.
And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance. And I'll submit.
All right,
Easy.
does the Commonwealth want to be heard on this?
No, Your Honor. Oh, he's got something to say.
Your Honor, the Commonwealth is relying on advice of appellate counsel.
What is happening?
I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible.
That's fair.
There is an
I
expedited
respect that.
scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns.
He's agreeing.
We understand the trial strategy for different charges.
He's agreeing.
Different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition or
Yeah.
going to allow oral argument.
Wow.
A benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the court will act more quickly.
Holy crap.
And that we can have this trial in April.
Okay. Well, I'm not going to grant the motion.
Oh, what?
Right? We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get.
I called it.
Starting April 1st.
Jurors.
At a minimum,
She's defaulting
10
on
weeks.
jurors.
I'm not going to do that.
Ta-
What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches.
Knew it.
And we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right, so let's go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of it?
Wow.
Because I don't know where I put it.
Can get one.
Jury problem.
I have it here somewhere. I'll find it.
I'm trying to scramble if it has
So we
merit.
did hear
Maybe
from
it
people
does.
this
Maybe
morning.
I'm
I
missing
know you all
something.
I have it. somewhere. I have it, Jim.
Thank you. Thank you.
I think Mr. McDermott gave you a copy of,
I don't know.
I guess, what local merchants have requested.
We've received them, Your Honor. Thank you.
Okay. All right, so I'll hear the Commonwealth on your buffer zone motion.
Oh God, buffer zone. Are they going to increase it now?
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned, based on past reports and information, that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be
What about sirens, Brennan?
influential, intimidating.
Did you see the first trial?
And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases and other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury.
Thank you, Ken Buchanan.
Affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone.
I mean, we already know what she's going to do. She did this last time. It was granted. She's going to grant it. Is she going to expand it now is the question. That's the real question.
The outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take no position.
Okay.
Smart move.
All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read and consider today's email from the merchants. Okay. Yes.
Could I just have this marked for identification for this hearing, identification? And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Oh.
Thank you.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyway. So. All right.
Your Honor, could I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules.
Oh.
I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations.
Yes.
It's mandatory.
Get
under
them,
the rules.
little.
We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
Yep.
So there is a footnote. I'll hear you, Mr. Brennan.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation.
Oh
of
my
witnesses,
God.
Which the Commonwealth believes is ongoing. I think a potential
Oh.
resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from...
I don't have a problem with that. I still need cities and towns.
Of course.
Okay?
Yes.
All right.
Sit down, Brennan.
Thank you. So we will start with, it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminated to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
Jackson or Unetti? Or no, Commonwealth. Wait, lack of bias. Wait, hold on. I'm sorry. I must have missed
Commonwealth
something.
first, Your Honor.
Well, it's defendant's motion.
Yeah, I was going to say
Commonwealth opposed it.
defense motion.
You would ask who's arguing that for the Commonwealth. That's why.
I'm sorry.
Yeah, defense.
motion.
I was like,
Okay,
wait a minute.
sorry,
That's why I got
apologize.
lost too. I was like,
could go first if
it
you'd
should have
like.
been defense.
Excuse me?
I could go first if you'd like, whatever the...
I'm fine with him going first if you'd like to.
Okay.
Okay, that's weird. It's defense's motion. Why is the Commonwealth going first? Translation from Auntie Bev says J. Road Less Wolf. I haven't had my immune cell. I had to put water in my magic 8 ball. Thank you for your dono. Chat is on fire today.
Part of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment, at the time they wrote the report, and then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is an undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern. The ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned as they should well before trial, in my opinion.
By the way, happy first day of spring.
The United States Attorney's Office.
I forgot to tell you all.
Two letters which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in
Allegedly,
which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently, and then subsequent to that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because...
Thanks, Bob Warren.
The second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply. But we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just asking the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
All right. Mr. Yannetti?
Thank you, Your Honor. Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate, right?
But the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking...
So, no, could you answer that now, and then I'll let you say everything else. Oh, you just said it's late. Hold on. You just said it's later in the argument.
I know, but you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Thank you, Bev.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation,
Sorry,
whether
Chat.
there was a federal grand jury, what that grand jury did, what that grand jury considered. Nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my client's, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed.
Just won't let me.
Really
I'm trying to do
perverts
something.
The truth in this
I'll do it
case.
later.
It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or
See,
opinion.
I installed this thing called Nightbot, and
Recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth
Slow down.
suggested that it was the defense that was playing hide the ball. When that inference is, again, the furthest thing from the truth. In terms of the
I can't edit it because the minute I go to edit it, my screen disappears.
Mr. Brennan engages
Let's
in
try
a
this.
ton of speculation about what happened or
What if I
didn't
do this?
happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal
Still no.
government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA, and they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with, and all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes. Respectfully, the Commonwealth does not look to hide the truth.
Yeah.
The reality
Oh?
is if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government, and the jury's entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered, and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case.
Which is surprising, because you should.
We don't have any interaction, not because we chose to hide from exculpatory evidence, so we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yannetti's
I disabled
file
Nightbot. Don't worry about it now.
information, whatever it was, his
I'll have to
entire
tweak it.
file was given to the federal government, and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right? So we're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later.
Auntie Bev doing Bev stuff.
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to.
Yeah.
And we're also conscious of the fact that we have a jury sitting for weeks at a time away from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made I had no idea what the basis of the objection was, and the court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but it's, you know, what's the basis for your objection? If it were that obvious that it could be ruled in open court, you know, we should have known the basis for the objection. I didn't know.
I agree with that.
And
We should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. You know, we think that this would, and look, you know, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, you know, trying to coach a witness or, you know, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It will allow my client to preserve her due process rights, and we'd ask the court to change its ruling from the first trial.
Okay. That motion is denied.
Of course it is.
So the next motion, defendant's motion eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that
Motion
All
granted.
right, so that motion's allowed, Ms. Giannetti.
She can't even say granted, just allowed.
There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors. other than
Liar!
the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So
Don't believe you.
there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan?
Welcher.
Welcher, and the Commonwealth's opposition. So who's arguing for the defendant, and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alessi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay.
So an hour.
All right.
On one
Before we
motion.
go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to.
No, there's no time limit.
To
Bev
appoint a
is just
stenographer, we've already done that.
she's just trying to
Prevent
do the easy
identification
stuff
of jurors
first,
and
get it out of the
impound
way.
juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
The defense should not really have an objection to this.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors, this case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized.
What?
It will chill, I think,
During the trial?
deliberation in a fair trial.
Have you lost your mind, Brennan?
I think it is a
After the trial, buddy. After the trial.
And under the circumstances of this case, I ask the court to do that.
Oh my God. Defense has no objection.
Objection from the defense?
Oh, okay. Yannetti has something to say. I thought it
Your
was
Honor,
just.
we have no objection to.
There you go.
Court stenographer.
There you go.
Including jurors'
Oh.
names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is
Called it.
Pursuing that
It's easy.
part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Well, if it's sidebar discussions regarding jurors, we're
Yeah.
in complete.
Yeah,
agreement.
yeah.
Sidebars are impounded regarding jurors, anyway.
Right, so we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR
Well,
on
that's
things
what I'd
that.
like to
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This
change.
is a new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information. But the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority, and I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right. So I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, one photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that,
objection.
Ms. Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Wait, redacting the manner of
case
death.
law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate.
What?
Certainly, the defense can cross-examine any witnesses at a call regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness.
What does it say?
An opinion regarding the cause of death, but the certificate itself should be redacted, and it should follow Massachusetts general laws, and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
What does it say? Does it say, like,
Thank you, Your Honor.
does it say assault or something that he doesn't like?
In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined.
Undetermined.
The Commonwealth is seeking to exclude this information from
Ah.
the death certificate because because it is exculpatory.
Yeah.
The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here.
Yeah.
None of the cases cited by the Commonwealth that were just referenced
Exactly,
by Attorney
Wolf.
Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined, and that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. There is no case law that suggests that the word undetermined should be redacted from a death certificate.
That's a good point.
The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw Dr. Scorti-Bello. Oh,
Not on their witness list.
right.
Just number 81 on the Commonwealth's witness list.
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize, I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner, so that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine, thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick, so that's paper 580, Jim?
Thank you.
Commonwealth's motion to eliminate with the intent to obtain Corey records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that, Your Honor?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Is it the common practice of this office?
He has to ask Lally. He doesn't know because he's
Your
special
Honor,
prosecutor.
Is the court's question common practice of giving everything, or is the common practice of running queries?
It actually seems to be both.
I believe I've been informed that it is.
That's
the
fine,
common
he doesn't
practice,
know.
and that is the practice we would follow.
Just
to
ask.
everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record and re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. And I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all, too, to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up, and I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to Sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that, you know, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're
But I
giving
thought-
the jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
That's going to be a long one. That's going to be the long one. Okay. You are muted. All right, folks. That is the end of the stream for today. What did we learn? We learned everything we already knew. Bev is corrupt, and she's going to continue because of whatever BS jury issue she has in her head. It's going to take 10 weeks to impanel a jury. Really? It's going to take that long? How? Why? It does not compute. It doesn't track, and I don't understand what she means by that and how that's even possible. Maybe I'm missing something. Like I said during the live, I told you guys that I don't exactly understand what Bev's reasoning is. And maybe she's got something. Sorry, my phone was too close to the microphone. And I think it was picking up signal. Maybe Bev, maybe it's true. Maybe it is going to take 2.5 months to find a new jury pool, and that's why she's so hesitant. If that's true, that's reasonable, unless Bev is somehow see, because this is why I said it's all hearsay that I heard, because people are, they tend to assume the worst, especially when corruption is going on. But not every single move that she makes is going to be corrupt. Like, you can't use that as your default. So when you think of it this way, it's possible. I can't rule it out. I can't rule it out. I can't sit here as an attorney who has experience in this regard to say, nope, the judge is pulling strings. And I will never say things I don't wholeheartedly believe. Those of you who know me know that I will never exaggerate or embellish just for the sake of entertaining. I'm here to educate more than I am to entertain. Edutainment, as we like to call on this channel. So with that in mind, the fact that Auntie Bev is like, well, I'm not going to move the trial date. We can revisit this issue at some later point. Because here's the thing. Her argument is maybe we pick the jury, we impanel the jury, we essentially imprison them in this case, and then hopefully by then you'll have a decision from the First Circuit. Maybe or maybe not. That's going to be up to them. That has nothing to do with me. So either the feds are going to step in and they're going to say, no, freeze proceedings. The proceedings are stayed. That's a term of art. That's a legal term. And that's it. Bev will have no choice in the matter because they're above her and they get to decide that. Or they don't do anything. The trial does start with jury selection. That takes 4 weeks. We have a decision from the higher-ups. And then at least you have a jury to play with. Charges 1, 2, and 3, or just charge 2. So it may work out. It may work out in the end, and maybe Bev does know something that I don't, that it's really hard to find a jury for this case because of the publicity that it has. So anyway, I am going to sign off for the day. I will not be back after the break at noon. I guess they're coming back. I don't know. Maybe they're doing, a short break. Maybe they're doing a long break. I didn't honestly listen because I have work to do. I really wanted to do this though, and I'm so glad that I did. I got the interesting stuff out of the way, and the rest is going to be up to you all to catch up on. I may tweet a thing or two if I see something, so be on the lookout for that. Follow me on X to have those updates so that you are up to speed. How confident are you, Larry, in what? I am a very confident individual. Like, is that what you're asking? I'm just kidding. I'm confident in what? Like, what are you talking about, KVP? While you're answering that, so yeah, questions. We have a few minutes. We can take questions while they're doing a break. That it may work out. That what may work out. Again, you're not giving me any guidance, buddy. Am I confident that it may work out? Which part? We heard like 15 different things this morning. So you have to be a little bit more specific. Unless you're talking about the Karen Reed trial generally, in which case, of course I'm confident because I trust our justice system in the sense that a jury is independent, unbiased, and uncorrupt, usually. I mean, we've all heard about Clarence Darrow paying off jurors back in the day, but this was like the 1920s. He was accused of it, and he was acquitted of it. I mean, I honestly think he probably was doing it. It was very common in those times to actually buy jurors because there was no media. It was newspapers. They're basically writing on stone tablets. Might as well be, you know. If he means in general, yeah, sure. I think things are going to work out. So like I said. But if you guys don't have any questions, I am going to sign off. I will be premiering a new video tonight. And tomorrow, hopefully, is the biggie. Like I said, I do have a special surprise for y'all. The DUI guy is cooking. I am in my basement with my cauldron with the little mole on my head with a big nose. Oh, you children don't even know what is coming your way. Now I sound like Popeye. I was supposed to be, I was trying to be a witch with a cauldron, but I ended up being more like a hybrid witch with a Popeye, and you know. When will we see Chandler again? You will see her eventually. She's working. She's working a 9 to 5, so it's up to her. And then she starts law school in August. So yeah, lots of good stuff coming. Be on the lookout. There's a video premiering every single day, sometimes multiple videos per day. So if you're not yet subscribed, what is wrong with you? Subscribe, damn it. Hit that like button, hit that subscribe button, drop a comment below if you got any questions at all. I mean, recently I started doing something new. I'm actually going to my comments section because now I have a special tool that allows me to like summarize comments. I don't have to literally sit there and scroll. So if you have like an idea, like I actually created a video because of your comments. Not lying. I created a video specifically because of there were so many comments on one specific topic. I was like, I'm going to make a video on it. And it's Beverly Cannoni and her corruption. So that video is going to be premiering in the next few days. I'm waiting on my editor to finish editing it because we have like stuff in the hopper through the end of April. I have enough content right now as we speak to basically have a video a day minimum until May 1st. So every single day, new video is coming out. So be on the lookout for that stuff. And all right, seeing no questions. I love you guys. Thank you all for joining me. This was a morning. Oh my God. This has set the mood for the rest of the day. I'm so excited to get back to work, and I will see you all in the next video. Bye, everybody.